is Tornado Watch Wednesday, December 18th, 2025. And this is the court gallery. Yeah, Thursday. I definitely meant Thursday. Because it's absolutely Thursday. And I knew that. I was just testing everybody. You know, that's what us old wolves do. Just want to make sure everybody's paying attention on Thursday, December the 18th, 2025. We're here to watch some court in the court gallery, and we're going to start things off in an interesting manner with Judge Gettler in Kansas, who has an inmate who's really not happy about being an inmate. And from there, we're going to visit our friend in Centerville, Michigan, and we're going to hear about a pretty trying DV case, a domestic violence case involving a son and his mother. Then we're moving on back into Kansas with Judge Ricky, who has a lot to say about a ex parte motion which stripped a 10-month-old child from its mother. And from there, we're going to be heading back into Michigan with Judge Johnson, who's going to get an earful and has a lot to say to a defendant. And you know when it's Judge Simpson winding up the end. Ladies and gentlemen, it's Judge Simpson in only the way Judge Simpson can be. He's got an interesting case that involves an inmate, some secret correspondence, some code words, and, well, we round things off with a pretty crazy guy, and it all starts right now.
State of Kansas versus Bobby Walton, 19 CR 140.
You want to come around here?
Mr. Walton appears by Zoom from Lansing Correctional Facility. He appears with, but separate from counsel, Mrs. Hearn, stayed by Mr. Gayoso. We've got the audio feed from Mr. Walton there, but we've lost video. I'm just seeing a black screen now.
He has moved around to my side of the computer because my laptop is not transmitting over there. So he can see everything and hear everything.
I can't see him though.
Do you want him to go back over there?
That'd be my preference. I'd like to be able to see him.
Okay. All right, hold on a second. Okay, there you go.
Thank you. All right, this matter comes on for, it's again a remand from the Court of Appeals regarding sentencing, specifically whether the sentence imposed in this case, 19 CR 140, should run consecutive or concurrently with, looks like 16 CR 151. It was ordered consecutive at the time of original sentencing. The court ordered that was required by special rule. Court of Appeals indicated it's discretionary, and so we're back today solely to determine whether these two cases, the sentences should run consecutive or concurrently. Mrs. Hearn, have you had a chance to visit with Mr. Walton regarding this resentencing issue?
So, Your Honor, not specifically about the issue. I have spoken with the state. I am in understanding what we're doing today. Getting in touch with him through the prison took some time, and our first meeting was not very productive. Actually, Mr. Walton indicated he wanted a different attorney, but I was hoping he might, change his mind about that once we had a chance to actually talk. Just this morning, the prison staff indicated he wanted to speak with me. I explained I would have to ask the judge for a breakout room, and that would be up to you, Your Honor. So I'm prepared to go forward this morning, but no, I have not specifically discussed it with Mr. Walton. I've prepared as to what the state has told me we're doing today. So.
All right, Mr. Walton, did you get to visit with your attorney in a breakout room?
Yes, sir. I would like to.
All right, let me get that room created and let you all speak, and I can take us to other matters in the interim.
Hey, how you doing? I got a client I wanted to talk to. You just,
I'm in Zoom court.
huh?
I'm in Zoom court.
Oh, you're in Zoom court. Okay.
You should have that prompt on your devices now. Ms. Jackson, if you'll get Robert Steele available, I think he's there to use the laptop, if I read your message correctly. Good morning, Mr. Lattin.
Good morning, Your Honor.
All right, State of Kansas versus Robert Steele. Mr. Steele appears by Zoom from the court laptop with, but separate from counsel, Mr. Lattin, stated by Mr. Gayoso. Mr. Steele is appearing on two matters today. One is MGI 25 CR 123. That is a motion to revoke probation, a case assigned to Judge Collins. And also appearing on IPD case number 25-2055. That is on for a formal first appearance. I don't show that a complaint information has been filed. Has that been filed, Mr. Gayoso?
Give me 1 second, Your Honor. The county attorney's office is requesting additional information on this matter that was sent back to law enforcement on December 12th.
All right. So as it pertains, Mr. Steele, to IPD 25-2055, that is a case that you were, it looks like, arrested on or about December 6th. The state is declining to prosecute you at this time. They're waiting additional information from law enforcement before they make that charging decision. So as pertains to that particular unfiled case, you have no further obligation to the court at this time, and you'll be released from your bond as it pertains to that particular case. That does still leave you, however, with MGI 25 CR 113, which is a pending motion to revoke probation before Judge Collins. All we're going to do on that today is pass that matter to Judge Collins's next court date. And I believe that's going to be on January the 8th.
Available on that day, Your Honor. So
That would be correct, Your Honor.
All right. All right. So, Mr. Steele, your next court date in MGI 25 CR 113 is Thursday, January 8th at 9:00 a.m. They'll be in person. So you'll be in the courtroom with your attorney before the judge on the bench.
Your Honor, I believe actually this, the 113 case is a North Half case.
North half? Okay.
That's what I'm showing. So it would actually be,
The 13th?
let me see.
maybe on the 6th, Your Honor.
I think it'd be 2 days earlier.
Oh,
yeah.
yes. I was looking at my docket week. So January 6th. So Tuesday, January 6th at 9:00, Mr. Steele.
Yes, Your Honor.
All right. Do you have your attorney's contact information?
Yes, Your Honor, I do.
Excellent. Stay in contact with him. Come back to court on Tuesday, January 6th at 9:00.
So, a question, Your Honor, on
Sure.
the other case that they sent back, do I still continue to do bond checks with Dan?
You are no longer on bond in that case. They're declined to prosecute. So no, unless it's required as part of your probation when you appear before Judge Collins on the 6th. As far as that case for which you posted bond, you're free and clear on that.
All right, thank you, Your Honor.
You're welcome.
Yeah, just for clarifying, he does need to keep reporting on the 25113 case, Your Honor.
Yeah, you are still on probation.
To
Just
my
to-
probation officer, yes.
Yes.
Yes,
I
okay.
understand that.
Excellent. Okay, thank you very much.
And Your Honor, that would just be set for admit or deny.
Yes.
Thank you.
Thank you, Mr. Lattin.
That's all I have this morning, Your Honor. Thank you.
Very good. Let me go ahead and call State of Kansas versus Samantha Tosh, MGI 25 CR 440. It is now 9:27. Ms. Tosh fails to appear. She was
And
present. Yes, go ahead.
Sorry.
No, you're fine.
I have confirmed that she is in Wilson County. She was trying to convince them to let her Zoom in, but they're not letting her do that from that jurisdiction, which I understand. But I know where she is. She's in Wilson County Jail right now.
All right. I appreciate knowing that. What we'll do then is just issue a bench warrant to act as a hold. And then as soon as she is released in Wilson County and gets back here, it'd be my intention just to give her a new court date and release her on the bond that she had previously posted. But just so we get her back to jurisdiction.
Can you tell me what that bond was?
I show it was 10,000 cash ready supervision.
Okay. Thank you, Judge.
You're welcome. All right. Thank you, Mr. Jones.
Thank you.
We will go ahead and recall State of Kansas versus Bobby Walton as soon as they rejoin us. Same appearances as before. Ms. Hearn, you and Mr. Walton have had a chance to visit. Any announcement for the court?
Your Honor, we definitely are not on the same page or have a consensus. He does want a different counsel. I don't know that he will have a different result. He's not on the same page with me procedurally as far as what's going to be taken up in this matter. He wants to discuss other things, and I tried to explain to him that this is what we're taking up. I don't think he's being unreasonable. I think he wants to address other things, and there's a way to do that, and I tried to tell him that, but he gets frustrated and if we get off track. So that's where we're at right now.
All right. If I don't know if you're addressing the, can you mute yourself, Ms. Hearn? I think I'm getting some feedback on your end. Thank you. Mr. Walton, you can go ahead and unmute your microphone for me. Can you hear me okay?
Yes, sir.
Okay. I just want to clarify, you may have some additional things that you want to take up, and we can certainly do that. But the sole reason that you are before me today, and the only thing that we're going to take up with, at least at this point in time, with Mrs. Hearn as your attorney of record, is resentencing in 19 CR 140 solely on the issue of whether that sentence should run consecutive or concurrent with 16 CR 151. That is the only thing that we're back on remand from the Court of Appeals to address. If there are additional things you want to take up, we can do that at a later date when that's probably before the court. But that is the sole basis for Mrs. Hearn's appointment, is simply to represent you for resentencing, to address whether or not those sentences should be consecutive or concurrent with each other.
I don't want her to represent me, Your Honor.
You don't have that choice. She's more than capable of handling this issue of whether they should run consecutive or concurrently. This is not a complex issue at all. And if it was, she's more than capable of handling it. This is a very simple resentencing where she and you can make arguments as to whether those two cases should run consecutive versus concurrent, and I'll make a decision of what that should be. But what's your basis for wanting new counsel on this particular issue?
She told you, Your Honor, we're not on the same page. She's not hearing what I'm trying to explain to her. She think that what I'm trying to explain to her got everything to do with what we're here for today. But she don't know what happened with me, and she's not trying to hear that. And I'm not okay with it. I need her to know exactly what happened to me March the 11th, 2024, when I got sentenced.
Well, what happened, Mr. Walton, that's pertinent for today is that your sentence was ordered to run consecutive with 16 CR 151. That's what happened. That's what we're addressing today.
Your Honor, when I got sentenced, did you not give me 32 months and 162 months, which made me have 194 months in prison?
We're not addressing, you were given 32 months and 16 CR 141 or 19 CR 140. That was the sentence you received, correct?
Along with another 162 months. And when I got to prison, I was only here on the 32-month sentence. I wasn't here for 190. I got released from prison last year. I wasn't supposed to get released from prison last year.
Okay, we're not addressing that today, Mr. Walton. We're here for a very specific issue.
When will we address this?
When it's properly before the court. So we're going to proceed with sentencing today, Mr. Walton. Again, we're here for a very narrow issue. If you have other grievances, we can take those up at a later date when it's properly before the court. And so, again, the primary offense for which you're being sentenced, which you should be familiar with, in 19 CR 140 is aggravated assault with a deadly weapon, a level 7 person felony. It was count 1 of the information. You have a criminal history score of A that was not disputed at the time of the original sentencing. The range for sentencing is 34 months aggravated, 32 months standard, and 30 months mitigated. This is a presumptive prison sentence. Per your plea agreement, there's no departures to take place. There are two special rules that apply, that being number one, person felony with a firearm that results in presumptive imprisonment, and special rule number 9, crime committed while on parole, that being 16 CR 151. The effect of that rule is the court has the discretion of ordering the sentence in this case run consecutive or concurrent with 16 CR 151, and that is really the sole issue that we're determining today. While incarcerated, you could earn up to 20% good time credit, would be subject to 12 months post-release supervision. So at this point in time, the only thing that I need to hear from counsel on and address, and I'll begin with you, Ms. Hearn, and then I'll address Mr. Walton directly, is arguments that these two cases, the sentence in 19 CR 141, that it should run concurrent or consecutive with 16 CR 151.
Your Honor, the court obviously has accurately stated the mandate from the Court of Appeals. I don't want to repeat all of that, although it is, I would consider it part of my argument. It was incorrectly stated that, or not incorrectly, but improperly stated as far as procedure, that this cases had to run consecutively. KSA 216606 provides that the court does have discretion. I couldn't find anything. Obviously, I wasn't the attorney on that when that was going on, but I did not find anything where a consecutive determination was agreed by the parties or part of the plea. Default is concurrent in these cases if the court isn't clear. And this is not a case where mandatory consecutive is required as to the same statute, subsection C, that I mentioned earlier. There is an issue where the courts like to avoid double punishment or double dipping for closely linked actions. Again, I wasn't the attorney on either of those cases. However, that is what we would be trying to avoid. Mr. Walton isn't, to my knowledge, has not incurred any new charges, has not had any issues. He has served a significant amount of his time, and I do think it would be appropriate for concurrent sentencing in this matter.
All right, thank you, Ms. Stern.
Thank you, Your Honor.
And Mr. I'm going to mute you, Ms. Stern. We're getting feedback. I don't know if you have this on YouTube, and that's why I'm hearing myself, or what. Mr. Walton, this is your opportunity to address the court on whether your sentence in 19 CR 140 should run consecutive or concurrent with 16 CR 151. Is there anything you want the court to consider?
Yes, sir.
All right, you have the floor.
All right. I would like I asked that they be ran concurrent because that when I got sentenced, Your Honor, I got to prison and I was only here on just this case. You know, they never knew anything about the other case. So I got released last year, August 2nd, and I was out for 10 days. I was on parole and everything. I didn't commit any new crimes. You know, I've been doing what I'm supposed to do in here. And you know, when I got released, they messed up my release date, and they messed up my custody level and everything. I was medium custody, and when they brought me back to prison due to y'all mistake, that made me max custody, which I only get 1 hour out a day. You know, and they really messed up my whole operation. You know. I just asked them if you ran to Garrett so I can do what I gotta do and go home to my family and get away from Kansas, John. That's all I want.
All right, thank you, Mr. Walton. Mr. Gayoso, on the issue of whether the sentence should run consecutive or concurrently.
Your Honor, the state's position is that this case should run consecutive. Mr. Walton is a criminal history A. He has extremely violent convictions. As the court mentioned in the 2019 CR 140 case, two special rules had applied in that case beyond him being presumptive imprisonment, which was that he committed the offense with a firearm and also while he was out on parole. I would also remind the court that in the 2016 CR 151 case, He was convicted in that case of 2-person felonies, which were ag battery convictions, as well as possession of a firearm. We have separate victims in each case, Your Honor, and this potential, buy one, get one free, if the court would order it to be concurrent, is not appropriate in this case.
All right, thank you, Mr. Gasso. Does either side know of any legal reason why the sentence should not otherwise be pronounced today?
No, known by the state, Your Honor.
None by the defense, Your Honor.
Very good. It is the judgment then, Mr. Walton. Your sentence will be as follows. I find the primary crime that controls your base sentence is aggravated assault with deadly weapon, a level 7 person felony. It was count 1 in the information. With a criminal history score of A, I'm going to send you the standard term of 32 months with a canceled term of corrections. That's what the original sentence that was imposed, 32 months of the KDOC. This is a presumptive prison sentence per special rule number 1, as well as you have a criminal history score of A. Special rule number 1 being person felony committed with a firearm results in presumptive imprisonment. Per special rule number 9, this crime was committed while you're on parole in 16 CR 151. That does give the court the discretion of ordering these two sentences to run consecutive with each other or concurrent with each other. For the reason noted by Mr. Gayoso, the fact this is an aggravated assault deadly weapon, that it was committed while you're on parole for 2-person felonies, you have a violent criminal history. It does not make sense to me to reward you by ordering these two sentences run concurrent with each other. And so I'm exercising my discretion and ordering they run consecutively. So your 32-month sentence in this case will run consecutive to the sentence that was imposed in 16 CR 151. You are eligible to earn up to 20% good time credit and would be subject to 12 months post-release supervision as was ordered at the original sentencing date. Court costs and fees will be the same as previously ordered. Credit per time served as previously ordered, I believe that was 683 days. Same collateral consequences, same right of potential expungement, and same right to appeal, 14 days. If you believe I have made an error today, Mr. Walton, you have 14 days to appeal this resentence on the issue of consecutive versus concurrent. And if you cannot afford an attorney for that appeal, one will be appointed for you. What other issues beyond this, now this is taken care of, Mr. Walton, if you can concisely inform me, do you think need to be addressed? We're not going to do it today, but I'm happy to perhaps set another court date to take up some other matters if you think they need to be taken up and if they're properly before me.
Yes, I do. I told you the issue, Your Honor. I wasn't supposed to get released from prison. I was never here on 2 cases. And when y'all sentenced me March 11th, 2024, y'all only sent me to prison. Y'all gave me 194 months. 32 months and ran consecutive with 162 months. But y'all only sent me to prison on the 32-month sentence, which I already had most of the time served. So I got released a few months after y'all sentenced me.
Released for 10 days. So what is it you're asking the court to do to remedy that situation you faced?
I want all my time credited. I want all of my time credited.
What time did you not get credit for as a result of you being released from prison for 10 days?
All the time from March 11th that I got sentenced on. I didn't get sentenced when y'all picked me back up. August the 12th. That's not when I got sentenced. I got sentenced March 11th on both of these cases. My time started when they said that my time didn't start until y'all picked me back up. That's not right.
Yeah, I'm not quite sure I understand, Mr. Walton.
That's why I was trying to explain to my attorney so she can litigate this for me.
Well, that's not what she's appointed, though, and that's why I wanted to clarify. She's not appointed to relitigate you having been inadvertently released from prison for 10 days. That's not what she's appointed. She's appointed solely for this resentencing issue on consecutive versus concurrent sentencing.
All right, so this 32 months that I just got, what I gotta do it again?
You don't have to do it again. No, the only issue that we're ordering today is that it run consecutive. Nothing has really changed. I previously ordered that this run consecutive to 16 CR 151, and the Court of Appeals said that I had to basically say that was at my discretion as opposed to mandatory. So that's what I've done today. I have found it's appropriate, and I'm exercising my discretion to run it consecutive. So nothing has really changed from what was previously ordered, other than just the manner in which it was accomplished. So your sentence has not been increased, it's not been decreased. Nothing has changed as far as the sentence that you received back in March of 24 or now.
Where is my parole? Was not on parole last year?
I'm not your parole officer. I don't track that stuff, Mr. Walton. That's beyond the scope of my duties. All right, so that's all we can accomplish today, Mr. Walton. I appreciate your time. Again, you have 14 days to appeal if you wish to do so.
I want to appeal.
Otherwise, we are in recess on Mr. Walton's cases. Thank you.
I would like to appeal.
You can discuss how to do that with Ms. Hearn.
Can we be placed in the breakout room?
I will set that up for you right now. Absolutely.
Thank you.
And ladies and gentlemen, before we continue to Judge Middleton, the obligatory Allen pause. And now, Judge Middleton.
You're welcome. You should have that prompt your devices now.
Mr. Gavin, would you come up and have a seat, please? Oh, okay. You're here on Gavin.
Yes.
He's in custody.
Yes.
Is he here yet?
Yes.
All right. Yes.
We have spoken this morning.
Very good. Thank you. Yes. That would be Mr. Gavin's mother.
You just like seeing John and I come here and not know 100% of what we're doing.
Well, you generally do know 100% of what you're doing.
I
But
know.
what John told me is he said, I was afraid of this. He said, I was afraid I would come here and I would like it.
That's anytime we learn some new law, that's exactly what happens.
Speaking of drama and colon, how's everything? How's everything there?
Pretty good as far as I know.
Well, good.
But I feel like sometimes you know more than I do.
Good morning.
Morning.
I'm Judge Middleton. I think we met by Zoom. I don't remember. Were we actually in here?
We met by Zoom, sir.
By Zoom. Well,
Yes.
meeting you in person here today.
Yes.
You're Daniel James Gavin.
Yes, sir.
This gentleman is Mr. Tyrone Fleeman. He is a law partner to your lawyer, Casey Strong. He's been practicing law for 25 years or more, and she's unable to be here, and she has prepared him for the case. I understand he's come and met with you this morning. Is that acceptable to you that Mr. Fleeman appears on your behalf?
Yes, Your Honor.
All right, thank you. Prosecutor, do you have any objection to that?
No, Your Honor.
All right. All right, Mr. Fleeman, what would you like me to know?
Your Honor, only that I think we are in agreement with the recommendation made from the victim impact panel that I know that Mr. Gavin has served the 30+ days at this point, and they're asking for a mental health assessment to ensure proper diagnosis and treatment, intensive outpatient rehab, no recreational drugs with routine mandatory drug screens, mandatory individual therapy, anger management, appropriate punitive damages as deemed by the court. I would hope that would be the 30 days he's already served, and then probation with optional residence at community probation to ensure successful integration back into the community. I don't know if that's necessarily the best place to go here, but I have spoken with Mr. Gavin about the fact that he needs to find a place to go, that he is not welcome to go back to the house. He has to find another place to go. And also, I forgot to mention that at some point you will need to schedule a civil standby with the police to go get stuff out of the house. You don't want to just go there without police going with you. Okay. And Your Honor, I'd ask that you follow the recommendation.
What recommendation are you referring to?
It's actually something that came from the victim themselves, and it was an email sent to Miss Ackerman, Kendra Ackerman. I don't know who that is.
She's kind of famous around here, but let's see if we can. I'm not.
And I'm reading from an email that went from Linda Gavin to Kendra Ackerman.
I don't believe I have that.
Oh. I guess I thought you would already have that. Would you like a copy?
No, I don't have it, but I'm certainly willing to look at it.
And from what I can tell, Your Honor, it looks like Mrs. Gavin prepared that herself. I don't see any other name on that. I don't know if she had help writing it.
Okay, thank you. Do you have it, Ms. Campfield?
No, Your Honor, which is, I'm just speaking with Ms. Ackerman about it. It typically goes right into our file through scanning and let me see.
So I was not crazy to think that you would
Let
have.
me correct myself. Let's see. I do have it, Your Honor.
Okay.
My apologies. I did receive that. And I would like to also point out that Ms. Gavin is present, would like to address.
Yes, I'm happy to be able to hear from her. This is a dynamic that we have often where there's a domestic assault and the assault is between the child and the parent. I don't know, we may have 20 of these a year. And this is sort of failure to launch syndrome. The defendant's 27, still living in his home. His contention was his mother told him he was a worthless piece of crap and he just sort of lost it. He indicated he was a chronic marijuana user, but marijuana is lawful for recreational purposes for adults. He's either unemployed or underemployed and really needs to launch himself. So let's hear from Miss Gavin first. I just now saw this. Would you come up and have a seat? You're Linda Gavin?
Yes, Your Honor.
And you're Daniel's mother?
I am.
What would you like me to know?
I have prepared a victim statement that I would like to just read to you.
Yes.
As mentioned, I am the victim of the alleged assault involving the defendant on 11/22. I'm submitting this statement to offer perspective, to illustrate its effect on me, and outline what I believe to be appropriate sentencing recommendations. At first, I would also like to say that I was initially not directly contacted by the prosecutor's office, specifically by phone, before the pre-exam conference on 12/9, even though I had reached out to their office on 12/4. On that same day, I also left a voicemail for the victim advocate, which I did receive a return call on Monday, December 8th. I'm highlighting this concern because I want to be certain that my rights were adhered to according to the Crime Victim Rights Act. And therefore, I'm here today to ensure that my voice is heard. The events leading to the incident on that day are relevant because it gives insight into his ongoing mental health challenges and current mental status on that day. At the end of September, he was terminated by his employer. And over the course of the next several weeks—
Who was the employer?
Peterson Spring Corporation.
Okay.
Over the course of the next several weeks were episodes of increasing explosive behavior, an episode of indecent exposure, and many episodes when his anger was disproportionate to the situation. He participated in online fights with people on Facebook who found his comments so disturbing that 2 individuals contacted non-emergency dispatch phone number. I was contacted on 10/4, at 12:29 a.m. to answer a call from an officer doing a welfare check. We also learned that during that time, he stole money from us to purchase marijuana. The day of the alleged assault, I was involved in a heated discussion with the defendant regarding ongoing issues of household expectations, pervasive lack of respect, marijuana use, unemployment, and improper use of social media. I was told, among other things, you're a loser, you're worthless, you're a piece of shit. In exasperation, I echoed those words right back to him to hopefully demonstrate a how do you like it moment. And unfortunately, it was at that moment I was struck on the left side of my head with a 24-ounce tumbler. I fell onto the bed, covering my head with both hands, and felt 4 or 5 additional blows with that same tumbler. I got up and attempted to flee, but I was chased into the next room and was pushed or tackled under the end of the couch, where I suffered repeated blows with his fist on my arms and back. I pleaded with him to stop, which he did, but then took my phone and locked himself in the bathroom. I repeatedly knocked on the door, begging for my phone. He questioned as to why I wanted it, which I replied that I needed to contact his dad. I wasn't feeling well and needed help. He finally gave me my phone, and I proceeded upstairs to my bedroom and immediately placed a call to 911. During the call, the defendant entered my bedroom, motioning with his hands to stop and could we work things out. I simply shook my head, to which he began walking toward me. I told him more than once to back up. As he lunged forward, I believe I stated, "Somebody please help me," before he grabbed my phone and fled the house on foot. After my phone was returned, I discovered both the location and the phone were turned off. This has affected both my physical and emotional health. I have a confirmed closed head injury with concussion and persistent symptoms of increased headaches, initial episodes of dizziness and tenderness at the pain at the injury site, large bruises on my left arm, small bruises on my back and posterior right arm, and right hand swelling and bruising. My emotional health has been significantly impacted with increased episodes of anxiety and persistent depression, along with symptoms that may be consistent with PTSD, such as flashbacks and nightmares. As a mother, my heart is devastated. And as a victim, I am pleading with the court to consider all options of rehabilitation for this individual. I am not seeking restitution or compensation. You see, this is his second domestic violence charge. The first charge occurred in 2022 when he assaulted his father. His employment history has been problematic, with a history of explosive outbursts, including 1 or 2 episodes requiring assistance from law enforcement after an altercation with a colleague several years ago. He has an extensive history of ADHD, ODD, learning disabilities with suspected bipolar or schizoaffective disorder, and autism spectrum. No formal testing has been done since elementary school age. He was a previous patient with Pivotal and recently established care. Our family was in process of seeking reassessment when this incident occurred. He has a history of chronic drug use and previous alcohol abuse. And in short, his mental health issues and substance abuse history have significantly affected his everyday life. Given his prior history of domestic violence and the severity of this incident, I would recommend the following: mental health assessment to ensure proper diagnosis and treatment program or regimen, intensive outpatient drug rehab, no recreational drugs with routine mandatory drug screens to ensure compliance, mandated individual therapy, mandated anger management course, appropriate punitive damages as deemed by the court, probation with optional residence at the community probation center. Furthermore, at the time of this incident, the defendant was a resident in our home. I'm requesting direction in proceeding with appropriate eviction measures, given his violent history and the fact that we are also in care of his younger disabled sister. Additionally, his father has significant health issues, including stage 4 kidney failure. All these factors, I believe, are reasonable in supporting our decision that we are no longer able to support the defendant, which includes residing in our home. I share this information with you as to not a point of blame, but to emphasize the seriousness of his issues and our concern for his future. His father and I love our son very much, but we are simply at a loss as to how we can help. So, Your Honor, please help us. Help our son so that he does not hurt someone else in the future. Thank you for your time and consideration.
Thank you. That was very eloquent. The police report indicated that they did call the ambulance service out to the house after you got hit in the head. I don't believe there was any blood. Linda was seen by Three Rivers Ambulance, but did not go to the hospital.
No,
She had several small lacerations on the left side of her head and a bruise on her arm. When did you get diagnosed with a concussion?
November 28th, I was evaluated at Three Rivers Health. I went there after work because I work for Beacon. And so I was having increased headaches and other concerning symptoms that were consistent with a possible concussion. And so I was evaluated at the ER.
I think if the prosecutor had known these things that you shared now at the time they took the plea, maybe we'd be in a different posture here, but I didn't know it either. But the question still remains, this is a problem with not a simple solution. He didn't wake up one day with all of these problems. I'm sure he had a very difficult time in high school. I'm sure he had a treatment plan, and all through elementary and middle school and high school, people that are on the autism spectrum often struggle getting through high school. There is a phenomenon that occurs, and I wasn't sure whether we're dealing with this or not, when young men in their 20s develop schizophrenia. They're living their lives, they're playing sports, they've got friends, and all of a sudden, schizophrenia touches you on the shoulder. There was a young man here in our county who was president of his class. He was a star athlete, all-state athlete, went to college, went to Boston University Law School and got a law degree. And just about that time, schizophrenia touched him on the shoulder and his life disassembled. He also assaulted his parents. He did pass the bar examination and was ultimately sort of admitted to the bar after a character and fitness hearing. And then he never was able to practice law. He never was to flourish. He's passed away since. And I've seen it hits men more often than women, at least in my experience. So what you're proposing now makes him homeless with zero support system. You guys have gotten to the end of your rope. He's 27. Has he ever lived independently?
He's 31, sir.
31. Has he ever lived independently?
No, he is not.
And so through all of these things, it came down to this. There was an earlier assaultive incident than this one. And I don't disagree, and I understand why you don't want him back in the house, but some of these things are difficult to put together. They're also very expensive.
Sure.
Your suggestion of Twin County Community Probation Center isn't a bad suggestion. It's a wonderful program. We're lucky to have it. It provides structure and housing, but he's a misdemeanant. And you have to be a felon to be eligible to go into that program. So I don't have the authority to put him in there. I'm a big fan of our Twin County Community Probation Center, have been since it started 45 years ago. Ms. Campfield, her suggestions are all about right on the mark. Do you have anything else you wish to add?
Your Honor, I think that those recommendations to the court are more than appropriate, particularly given the extensive history that she's indicated was the precursor to this incident and the severity of this incident. This is something where it wasn't just fist blows. She was struck with a metal tumbler in the head and is still suffering because of that. Do you know how much credit he has, Your Honor?
26 days.
I'd recommend a 90-day jail sentence with credit for 26, and then follow that with at least a 24-month probation.
Then I only have 3 days worth of leverage left. It's a 93-day misdemeanor.
Oh, that's correct. No. Oh, did he plead to a first or a second?
He pled to a first. No, perhaps you're right.
I think he pled to a second offense, Your Honor.
He did plead to a second offense. All right. That gives me 365 days.
So I would like to see the remainder of that time held over his head for mental health treatment compliance and no new assaultive offenses or behavior during the term of probation or any other violations, in order to take medication as prescribed, to not utilize alcohol or drugs that are illicit, to test upon demand. And I think it's absolutely appropriate that he have individual and group therapy, and that should include a domestic violence intervention treatment.
Well,
that should be completed.
That's a lot to pile on here. That's also expensive. But all right, I haven't heard. So we're going to try to fashion a plan for you, Mr. Gavin. You did accept responsibility for this. You told me that you hit your mother in the head with a tumbler. You actually gave her a concussion. You have a feeling of worthlessness and inadequacy. Your mother and father are frustrated. You're 31 years old. The current plan would be for you to live in your parents' basement for the rest of your life. And that's not that great of a plan. But I can't just dump you out on the front steps of the jail and make you homeless and penniless. I need to put together some sort of a plan, and I'm going to need help. I don't have a magic wand and have an expensive, intensive outpatient drug rehab program. I don't know what your drug is. We don't have extensive outpatient rehab for marijuana use. We have people that have opioid dependencies and methamphetamine, and both are very difficult to deal with. Have you dabbled with methamphetamine?
No, sir. No, Your Honor.
Or opioids?
A little bit, Your Honor, in the past.
What kind?
Xanax, Percocet, sir.
All right, Percocets might qualify. And so they don't have an intensive marijuana treatment protocol. Alcohol is also in there. But we do need a number of things. We do need a mental health assessment to ensure a proper diagnosis and treatment regimen. I think you did the anger management course the first time. That class cost $680. The full domestic violence course. There's a probation oversight fee of $40 a month. There's fines, costs, attorney fees. You don't have any money. You're not unemployable. You've had employment, but because of your mental health situation, it's difficult for you to maintain regular employment. I don't encourage looking for disability at this point. I'd like you to have some sort of a life, friends, associates, things to do. But you've never lived on your own. And You're gonna have to start. This is a 1-year misdemeanor, not a 93-day misdemeanor. I didn't give you a chance to say anything. Is there anything you'd like to tell me?
Yes, sir. I just wanted to reinstate the fact that I agree on everything that's been stated about my mental health and receiving treatment. And I also wanted to reflect back on the fact of the housing, that situation. My father has told me that he knows well, we have a friend of the family, sir, and he knows someone who runs like basically a halfway house for people like me to get kind of their life back together. It's private practice. And then also Lauren from Pivotal at the jail, she told me something about free housing.
Well, I contacted Lauren after I talked to you the first time. Lauren is our mental health liaison, and she's doing just a wonderful job. We had some good service, then we had some gaps, and she's doing a great job. So I asked her to meet with you to help me with what we're going to try to do here. So good. She can help me find a treatment program. She may be able to help me find a residential program that'll help you take one step at a time. But I'm not just going to let you out of jail and stand on the front steps with 2 cents in your pocket and no socks. So you're going to be in jail for a while longer, which probably includes Christmas in the St. Joe County Jail. I am going to order 90 days jail credit 26. I can amend it. That leaves 54 days to serve. I can amend it up or down because I'm putting in a probation for 24 months. The fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, and a $960 probation oversight fee. Now, the clock is ticking here. That's not right. 26 and 54.
64, Judge.
64 days. Thank you. We often have to add things up in landlord-tenant. I use a calculator, but 64 days. You get 5 days a month good time. So 90 days is 75 days. So I want enough time to try to figure out some placement options for you. Let's add that money up. $1,235. Payment due in 1 year. No drugs and no alcohol, and test as directed. Now, as I said, it's legal for adults to smoke marijuana in Michigan for any purpose they want. They can't do it in certain places, but they can, just like you can order a cocktail, you can smoke marijuana, except when you're on probation. You can't drink any alcohol and you can't use any marijuana or any other drugs unless they're prescribed by a doctor. Have you ever been on medication for your mental health?
Yes, sir.
What kind of stuff were you taking?
Medication for my depression and anxiety, sir.
All right. When were you last connected to Pivotal?
About a month before I came in.
All right. Well, that's positive. Cooperate with pivotal and follow recommendations. Sign a release. Let's say they find a place for you to go, an inpatient program that helps young men get on their feet. I can amend the probation and let you out of jail sooner than 64 days. But this isn't going to be something that they're going to snap their fingers and they'll have a place to put you. But we're going to look for something like that. Because you need to start somewhere to help you get your feet on the ground. They've got the Twin County Probation Center would be a great place. They give you a place to live. They'd help you find a job. They'd help you find alternative housing, like some of these places you're talking about, to transition from the probation center to one of these shared housing places with a job. Do you have a driver's license?
Yes, Your Honor.
All right. Do you have a car?
Yes, Your Honor. It's not in function right now, but yes, I have a car.
All right. Well, that's a plus. All right. Your mother is seeking intensive outpatient drug rehab. I'm not sure about that. I do agree, no recreational drugs with routine mandatory drug screens. We're probably also going to pursue individual therapy, but we need a mental health assessment to assure proper diagnosis and treatment. That starts right at the top. So let's figure out what services you need and then see if we can find a source for them. But in the meantime, you're going to stay in jail. The probation department's going to come out to the jail and see you or contact you by Zoom. I was hopeful when I talked to you at the time of your plea. You accepted responsibility. You've been very receptive here today. That had to be hard to hear your mother sit there and read that stuff. You want to be a better son, a better son, but you get what you get. You didn't ask to have a spot on the autism spectrum. You didn't ask to have a mental illness, but this developed over your entire adult life. You've been living in your parents' basement since you were 18, and it's developed into this toxic relationship. And it's going to have to start by you living somewhere else. They're still going to be your parents. It's going to be an unhappy Christmas, but at some point, there's going to be some sort of reconciliation, and maybe you can be more successful in your life. I don't know. Anyway, you can go with the court officers. I'll notify the probation department, and we'll stay in contact with Lauren Frank and see if we can find some of the things you're looking for. All right, thank you for being here. It was very helpful.
Thank you.
Judge, that 1235, did that include the probation oversight, or was that just the first block?
125, 150, and the probation oversight of 960. So that can actually be
that
cut.
1235 did include it. Okay.
Yes.
Gotcha. Thank you.
I think I might have left something out. 960 plus 150 plus 125 is 1235.
No, that sounds right. Yeah.
Thank you, Mr. Fleeman, for coming and covering for this.
Thank you,
It
Judge.
would have been hard to reschedule this, and I appreciate it. I understand we have Ms. Strong back this afternoon.
You do, yes, and she'll deal with that other matter that I think the court reached out to her.
Yeah, we got an extra case, and
She politely told me I was not qualified. So
well, it's a difficult case, and to do it on the fly, you're not qualified, but
certainly not prepped.
Not prepped, and she's got the background. So,
Absolutely.
All right, thank you, and I won't see you. Well, I might see you tomorrow.
Yeah, I think you do actually. I think I'm in tomorrow morning, I think. But if not, have a good holiday.
All right, you too. Thank you. Ms. Campfield, I hope we can make some progress with that young man, but he's got a long way to go.
This is Natalie Miskell, respondent, case number 2025 DM 51. Beginning with the petitioning party, would counsel announce appearances for the record, please?
May it please the court, Your Honor. Petitioner Daniel Garrett appears via Zoom and bind through counsel Chase Vaughn.
May it please the court, Your Honor. Natalie Miskell appears by counsel Devin Seward.
Okay, I've got Daniel Gayer apparently on a separate Zoom. All right. Very well, counsel. This is a paternity matter. The court notes not only the contents of the petition, but also of the answer to the petition, which appears there is no contest regarding parentage of this child. Is that correct?
Yes, Your Honor.
All right. The court at this time can make a finding of paternity and essentially maternity as well, that the parties to this case are the natural parents of LM, a minor child. And further orders in this case would be appropriate as a result. I'll also note for the record that apparently Mr. Gayer was named on the birth certificate as the father, and Natalie Miskell obviously as the mother. There is no contest over the issue of parentage in this case, and therefore the court can make this a decree of parentage at this time. Now, with that said, what issues do we have? Mr. Vaughn, your views first.
Judge, I think primarily the issue is going to be parenting time in custody. Our position obviously is reflected in the temporary orders, with my client being the primary custodial parent at this time. My understanding is that they're wanting the same, but with the respondent being the primary custodial parent.
All right, Mr. Seward.
Yes, Your Honor. Hold on one second, Your Honor. We just had somebody come in the door, and our secretary is out having surgery. Do you mind if I handle that real quick?
Go ahead, counsel.
Okay, sorry.
All right, Mr. Seward, let us resume.
Sorry about that, Judge. We are short-staffed today. So it's my understanding that, there's nothing been, gone through the courts up until now. Both parties live together. The baby was born in February, so it's, basically a newborn, less than a year old. So everybody lived together. They had a big breakup. The cops got called. My client got charged with domestic battery. Everything I've talked with her about, it was pretty flimsy. It sounded like the petitioner was the one who was drinking. She was trying to prevent him from driving to go get more beer. And that's essentially kind of how this whole case got started, the bad separation. My client got charged with domestic battery. She took a diversion to it. She's told me in private that she didn't actually hit him at all. So, take that for whatever it's worth. Because of that arrest, Mr. Gayer took the child and he, left and he went and lived with his parents. And so he's had the child this whole time. And my client came in and she's just desperate to get her child back and to have some sort of, solid parenting time. And, she works a night job, so she doesn't have any trouble. And she also lives with her mom, so she doesn't have any trouble with any kind of parenting time schedule. There's really no limitations. I mean, she's willing to watch the child at any time. So I don't know. I mean, our position would be that we would love to have, shared residential custody, potentially a week on, week off. There's a little bit of a distance between where the parents are living right now. And so that's kind of the biggest issue, I think, in the case is just, meeting somewhere halfway and having those exchanges. I think through the diversion order, I think there is still a no contact between the parties. And so that's something where, again, Natalie's mom is willing to help out as much as possible. So the maternal grandmother, she's willing to help out on all fronts to, make sure anything goes smoothly, and she could help do the exchanges if need be. Um, Yeah, and so it's something we had an issue with. I mean, we're pretty much looking to modify the temporary orders today. I mean, that was the big one, was the residential custody within the temporary orders. They claimed that the petitioners had de facto primary custody. I mean, I don't know if that's true. I think both parties lived together, and they lived at the address that Natalie lives at now. So the child from birth until this arrest in October had lived at Natalie's house. And, it wasn't until October, so a couple months ago, that it moved, residences. And then the other part in their motion was they put that he is the primary caretaker. And, everything I've heard from my client is that she was the primary caretaker. She's done all of the raising of that child, the nurturing and the changing of diapers, just everything from what I've heard has been on her part. And so that was kind of the big issues that we took with their temporary orders. And we would just like a fair, residential custody setup, like a parenting plan that makes sense for both parties. I mean, I think the relationship is, the relationship aspect of this case is over. I think the parties are not going to reconcile. I think they got to move on and try to co-parent. And so I think my client's willing to do whatever it takes to, help her daughter. And she's willing to, she's going to put her daughter number one in every aspect of her life. And so with that, I mean, we just ask the court to give her as much time as possible.
Your Honor, if I may, there was one additional issue that I did not bring up to the court. We also requested that the minor child's name be changed. Now I know case law, where we're at with that is that my understanding is unless parties stipulate to this court making a decision on the name change, I think I'd have to file a separate name or a petition for a name change. So I don't know if they're either willing to change the name or stipulate that this court has the authority and jurisdiction to make that decision one way or the other.
All right, Mr. Seward.
Your Honor, we would not stipulate to either one of those things.
I think you have the direction you need on that issue, Mr. Vaughn.
Yep.
All right. Mr. Seward has made a suggestion here regarding modification of the temporary parenting plan. Your response to that, Mr. Vaughn?
Judge, if there hasn't been any motion to modify on file, I know they filed an answer, but if they want to file or if they want to change the temporary orders, I think we need to have an evidentiary hearing on that.
Yeah, we did file a motion to modify.
Well, except, Mr. Vaughn, that your order was entered ex parte with no input from the other side, as ex parte orders generally are,
Correct.
Claiming that your client was the de facto custodian when apparently just because that there was an incident that separated the parties, he apparently just took possession of this baby and won't give it back.
Yeah. So
now he does. In all fairness, Mr. Vaughn, and I think perhaps even going beyond what the ex parte order should do, he suggested, and this court adopted, some way that the mother could have some court-ordered visitation with this child. But how old is this baby, born in 2025? How many months?
February, so about 10 months.
Yep.
All right. Is the mother in this case facing any drug-related charges, or is she on any drug-related probation?
No, Your Honor.
Oh.
So, Judge, just I guess to respond then, The issue is determining, okay, well, how do we establish de facto custody? Is it a week? Is it 3 days? Is it a month? At the time we filed this action, I believe that the child was in his care for about a week and a half, solely. So, I mean, that's the basis. We had a good faith basis for claiming de facto, but understanding the situation, as this court indicated, it is important to my client that their child see her mom. And so that's why we put that in there in our request for the temporary orders.
Mm-hmm. Understood, Mr. Vaughn. Understood. We're not apparently looking at a situation where the mother abandoned this child, left this child to the father for him to fend day to day, trying to take care of a small infant. The court has seen instances just like that, but that's not what we have here. Apparently, there was an incident that broke up these parties. The baby had to go somewhere. The father took possession. And that's the basis for the de facto custody in the case. But I think regardless of what the temporary order says, and regardless of the situation that existed at the time the case was filed, we need to go forward from here. What's the most appropriate parenting plan going forward? Why would the mother be restricted to every other weekend visitation, Mr. Vaughn? What's the justification for that?
Well, Judge, we would dispute their characterization of the incident. The fact of the matter is, mom was arrested for domestic battery against the father when he was holding the baby in his hands. If the roles were reversed, I think there would be, in most cases, there would be significant concern about an abusive father. Kansas isn't a preferential state as far as mother to father. So the fact is, we have someone who has stipulated on the record in our criminal case to domestic battery against the child's father. But as far as orders, I think it's appropriate that she would get holiday parenting time. I don't know what that would look like, but this isn't a case where we're dealing with property. I don't think there's going to be a lot of witnesses. I guess my request would be that we give her additional holiday parenting time and then set this for trial sometime soon after the first of the year. I don't anticipate issuing any significant discovery. I think, at least from my position, it can probably be exchanged by agreement of the parties to expedite it.
Oh. And in the meantime, your client holds all the cards. All right. I need an explanation on something in your petition, Mr. Vaughn.
Yep.
Assist the court, if you would. The petitioner, which of course references Daniel Gayer, and I'll just note that the court's not a big fan of lawyers' tendencies to refer to people in domestic cases as petitioners and respondents. I think orders and motions are hard to follow. Mother and father at this point seems appropriate, or perhaps just use the parties' names. But with that said, petitioner filed a PFA against the respondent, which I am presupposing then means Daniel Gayer filed a PFA against Natalie Miskell in Greenwood County case number 2025 DM 50. However, no temporary orders have been issued in that case. So what's the status of this 25 DM 50 case?
Judge, so I do not represent Mr. Gayer in the PFA. My understanding is that court ordered those cases to be consolidated. I haven't seen anything come through on that. I don't know if that's something we need to do proactively by agreed order between myself and Mr. Seward. I guess I would defer to the court on that, but my understanding is that court wanted it to be combined with this case.
All right, so that court, the magistrate court, I presume,
Yeah.
declined to enter temporary orders, didn't dismiss the case, left it pending,
Yes,
hoping it would be consolidated with this one.
correct. And to my knowledge, it is still pending.
Okay, well, there's no conflicting order in that case. And it doesn't appear the matter is even going to be set for trial at this point, unless Mr. Gayer is aware of a trial date that's actually been established. It's your case.
Hey, Your Honor.
I'm sorry.
So, hi, I'm Daniel Garrett. So the case for the PFA was just temporary orders for it was just just in case until the no contact thing was figured out. It has been consolidated. It has been dismissed. At the first hearing for the PFA, we were both told that she was supposed to set up supervised visits, and then we had a second one. I can't remember the exact day right now, but it was dropped, and it was consolidated, my bad, into now just going into this.
Okay, well, that's news to me.
Okay.
So, Judge, I'm going to deal with the case which is properly before this court at this time, and that's 25 DM 51. I was just curious about the case history and status of the other case that could have resulted in conflicting orders with this court. I don't want to suggest for a moment, Mr. Gayer, Mr. Vaughn, that you proceeded in anything but good faith here. However, the ex parte order is only meant to be an interim order until the court can make a determination, first of all, of parentage. And then once that's done, the court needs to make appropriate orders in the best interest of this child. We've got a 10-month-old baby, and I'm not going to have the mother begging for whatever crumbs Mr. Gayer's willing to throw her. If they have a bad relationship that resulted in some sort of domestic situation, maybe you guys need to be apart. Maybe your relationship's not working. This paternity case almost assumes that you're not going to co-parent this child in the same house anymore. So the court's going to treat mother and father at this juncture as equals from this point forward. The court's going to enter an order of joint legal and shared residential custody effective immediately. I'm going to require turnover of the child to Natalie Miskell at a date that Mr. Seward suggests. Is your client in a position to be able to take the child now?
Yes, Your Honor.
Okay. Well, I do want to have an orderly transition.
I think maybe Saturday.
Excuse me?
If Saturday would be work for everybody.
Okay. Mr. Vaughn, Mr. Gayer, is there any problem with Saturday?
So are we looking at a week to week or?
We are.
Okay.
As modified by the court orders here in just a moment.
So if we're looking at a week to week, I would think Sunday or Friday would be appropriate just because, it breaks up their weekend. That way both of them have a full weekend with the child.
Is there any possible way we could do Sunday to Sunday? Or Friday to Sunday? All right.
Or leave it up to.
Well, I'm concerned about the period of time that the child's been separated from the child's mother, and I want to have that transition sooner.
Yeah, if we could just
rather
do
than later.
Yeah, Friday.
At this point, I'm going to order Friday to be the exchange. 6 p.m. is a normal time for exchange. And it seems to me that I think we're talking one parent in Douglas and one in Eureka. Seems like the midpoint would be El Dorado. That would be about a half hour for both parties.
Yeah.
I think the parties were meeting at was it the Shell station? Or not Shell.
It was the
Sinclair gas station in El Dorado.
Okay, address?
Judge, I don't know it off the top of my head, but I think it's the only one in El Dorado.
No, there's two of them.
Oh.
Yeah, it's the east side one, the second one.
Right there by the movie theater and the police station.
Yeah.
At the east side Sinclair station, in El Dorado, Kansas.
Yes,
Will
Your
be the
Honor.
exchange point, 6 p.m. And Mr. Gary, you need to be on time. Mr. Seward, your client needs to be on time. Neither parent should have to wait on the other. They should both be there at 6, make the exchange with whatever formula or diapers or whatever would be appropriate to exchange, clothing, coats, that kind of thing. I trust each parent has access to a car seat, an
Yes.
approved car seat. That's absolutely critical. And I do realize Christmas is coming up. So while the court obviously supports the mother having custodial parenting time in the very near future, the court also doesn't want to deny Mr. Gayer's side of the family an opportunity to actually celebrate and having the baby in the household as they do so. As is obviously the baby's not going to be aware that it's Christmas as a practical matter, but it also doesn't mean that the rest of the family wouldn't want that child there. So the court's inclined to make an exchange, perhaps Christmas morning from mother to father.
Yeah, we already have an established time of day to do the exchange with Luna.
What time is that?
Christmas Day, 4 p.m.
Okay.
Okay.
I appreciate that, and the court will make that the orders of the court.
Okay.
That, in essence, would probably be the effective start of the father's week, which is likely to be an extended week. With 6 p.m. on Friday exchanges after that point.
So am I picking? Okay, so if it's starting, I'm just asking, this Friday, she gets her for this week, and then Christmas Day, she'll be doing an exchange back to me?
Correct.
Okay, okay, just making sure.
All right. Mr. Seward, I'm going to ask you to draft an appropriate order stemming from today. Begging the question here, Mr. Vaughn, did you want a separate decree of paternity?
I think that'd be appropriate, Judge.
Plan order? Excuse me.
Yeah, since they're not stipulating to the name change issue or addressing it in this case, I think I'll need that.
All right. Mr. Vaughn, if you'll just draft the journal entry of determination of parentage in this case. Mr. Seward, you'll draft a temporary parenting plan order setting forth the exchange location, exchange time, and the week-to-week joint and shared custody schedule that the court has temporarily adopted. Probably the relations between mother and father are strained right now, but the reality is we need to just go forward from here and put any contention in the background and just do what's right for this 10-month-old, because none of this is the 10-month-old's fault. So we just need to make sure that that child is protected and cared for and co-parented in the manner in which it deserves. If you'll pass that message along to your client, Mr. Seward. Other issues can be sorted out with the assistance of lawyers later. All right. Mr. Seward, is there anything else that you believe we need to address currently?
I don't think so, Your Honor. I think that's everything.
Mr. Vaughn, anything further at this time?
Judge, as a procedural matter, I don't get in front of you as often. Do you require parties attempt mediation first before setting a trial, or
Generally.
Okay.
Is there any possibility that just with counsel on both sides and these parents starting a co-parenting relationship on a joint and shared basis, that there might be able to be some negotiations take place before we get outside professionals involved? Your thoughts on that, Mr. Vaughn?
Judge, I've never met Mr. Seward's client, but my client, I mean, you've heard him today. He's I think he's pretty reasonable. So I'm optimistic. However, my only thing is I don't know if we could set that out, even if we're looking at mediation sometime in February. that gives parties ample time to try to resolve it, but then we're not needing to get back in front of court to get that set up if it's going to be an order.
I think what you're suggesting, Mr. Vaughn, is that if the parties would be ordered to enter into good faith negotiations, if those negotiations are unsuccessful by January 31, then the parties are to participate in some sort of alternative dispute resolution, which apparently you're suggesting mediation.
Typically, Judge, unless you have a different preference.
Well, who do you have in mind to conduct the mediation should it be called for later?
Your Honor, I know Angela Meyer in Pittsburgh. I don't know over your way. Does Amy Ross, does she, trying to think.
I'm familiar with that name.
Yeah, I'm trying to think of attorneys over. I don't get over to Greenwood County as much, so I'm not as familiar with that area. So if the court has a recommendation or someone they've used in the past, I'm more than willing.
Okay. Many of the persons who engage in alternative dispute resolution on behalf of the court office in places like Wichita. I'm trying to stay a little bit more local. Mr. Seward, do you have any suggestions?
I mean, I'm the same as Chase. I mean, I primarily work in Wichita. I mean, I have a list of all the mediators in Wichita, so I mean, I could send that to him, but you know.
Why don't you two at least confer over that? And, you know, we have a little time before it would actually be implemented.
Yeah.
And determine if it comes to that, just kind of have a pre-arrangement as to who you both agree upon, perhaps with consultation with your clients.
Okay.
All right.
Yep.
Court would so direct. That more directly deals with the parenting plan than it does the determination of paternity. So, Mr. Seward, that clause regarding January 31st deadline regarding good faith negotiations to settle issues and mediation to start in February if they're not settled, if you could include that in your order.
Okay. Yep.
Hey, Your Honor. Just a question. So if both grandparents are there, are me and Natalie allowed to talk about discussing Luna?
You think that's necessary to have supervisors there before you two can talk about your child?
I think his concern,
No,
Judge,
because of the no
criminal
contact.
case.
Mr. Vaughn, I want to hear from Mr. Vaughn.
Okay.
Yeah, I think my client's concern, Judge, is the criminal case. I agree. Parties need to be able to communicate.
Does she have restrictions through the diversion agreement?
Your Honor, I'm not sure if she does. That's something I need to take a closer look at. I just know she's agreed to a diversion, and I think she acted like there was a no contact. But I'm not 100% on that issue.
Well, I don't want her to do anything that would be contrary to the terms of her diversion agreement, first of all. So that needs to be checked out. But with that said, otherwise, maybe that's the best way for the parties to talk right now is to have somebody there to kind of supervise and stay out, but nevertheless, just be there to make both sides comfortable. Your suggestion is not a bad one, Mr. Gayer, but I don't know what restrictions she might have in a diversion agreement. And quite frankly, I don't know why a criminal court would want to get involved in interference with parents who have the constitutional right to parent a child.
Yeah.
I do understand that they may need to have some restrictions on contact with each other, some reasonable restrictions on communication and conduct, but keeping them apart from one another makes no sense.
Right. Thank you, Your Honor.
All right. So, Mr. Gayer, for whatever it's worth, I like your idea.
Yep. And Sam, if we need to sign something to modify any no contact order to nonviolent contact, I'm sure my client would be agreeable.
Yes.
Okay.
Well, thank you, Mr. Vaughn. I appreciate that accommodation, but again, there's apparently a county attorney or a municipal prosecutor's office that has to be involved in that decision as well. So I appreciate the attempt at cooperation here. All right. Mr. Vaughn, anything else further at this time?
No, are we going to set a review date, Judge?
Okay, I was thinking that you wanted to try to avoid that necessity. I'm certainly open to it.
No, I think we can avoid that. I just didn't know if the court wanted one. Since we've got kind of a directive on trying to work this out and then looking at mediation, if mediation doesn't work, then I think at that time we could probably just set a date.
Okay. All right. Let me know if you need another hearing date on any issue, counsel, and we'll get one worked into the calendar somewhere. January and February are already quite busy. So no winter slowdown in our court system. All right. Garrett, I just hope that you work in good faith to just try to do what's best for your child in relation to working with the mother. And she does the same.
Absolutely, Your Honor.
Last but not least, Mr. Vaughn, I don't know whether your client wishes to indeed pursue the change of name.
Mm-hmm.
If so, that action will need to be assigned to this court.
Okay. Yep, I imagine we'll be getting that drafted in short order, Judge.
If filed in Greenwood County, there should be party matching that would cause that to automatically happen. But unfortunately, as I understand it, the system needs to have such similarity between the parties identified in the system, or the computer won't know to assign it to the same judge.
Yep.
So often it can slip up. So, but it would be the intention of the court to hear the name change action as well, since it is at least related to this current action. Okay. All right. Very well then. That said, thank you, counsel, for your presentations to the court and your involvement, Mr. Gare. If there's nothing further at this time, then this paternity matter will currently be in recess, and this meeting may be ended for all. Have a good day, gentlemen.
Thank you, Judge.
This is case number 2509812 LT, the Addison at Southfield versus Elizabeth Anderson and occupants.
Can I speak to you privately, Judge? I filed an adjournment.
Excuse me?
I filed.
First of all, who is speaking?
Elizabeth Anderson. You just called me.
Ma'am, we don't know who you are. I can't even see you.
That's what I'm saying. The cameras went out. Let me see. Nope, that's not it.
Your Honor, if I may put my appearance on the record.
Yes, go ahead, please, Mr. Newman.
Thank you. Philip Newman appearing on behalf of the plaintiff.
And now, ma'am, you have to tell us your name for the record.
My name is Elizabeth Anderson, and I asked to speak to you earlier before court because I asked to be adjourned because I just got out of the hospital. Well, I have spinal surgery. Still have a hole in my spine. I'm so weak. I've been trying to call lawyers, and the ADA was supposed to help me because they refused to honor my disabilities, which is a federal law. Then now they done dug up all this stuff, and he filed and said there were no issues with the apartment. Do you know how hard it was to walk down the stairs? And I got a big old cyst on my back because, let me go in here. And then you go in there, they all nice. Then they want to pull that Karen roll. They'll call the maintenance man and try to bully you, but that's not even the point. The point is, I haven't had a chance to find a lawyer. I haven't had a chance to do nothing. And I'm in chronic pain. And I called, and they told me just to log in and tell you that I did file all that paperwork. Now, I have also email correspondence that I asked them where can I send the emails with the correspondence on it? And I submitted a video where the maintenance man is saying that the corporate didn't want me to have safe bars and all this. And then I couldn't come home from the hospital, but they left all this trash and dirt in the tub. And yes, I plan on moving, but right now I can't do anything. I can't even drive for 2 to 4 weeks. And with all this stress, I'm not
Ma'am, could you hold on a second? I think I understand what you're saying, that you've been ill, just got out of the hospital, can't move, haven't had a chance to talk to a lawyer, things of that nature. So this is a landlord-tenant hearing for termination of tenancy, meaning the landlord just wants the property back. So I don't know if there's any issues regarding that or not, but you said you want to talk to a lawyer. Is that what you want to do?
My own lawyer, yes, because it's
Okay,
just so
ma'am,
much
hold on,
more.
hold on. I can give you an adjournment to seek counsel.
Your Honor, if I may address that for just one moment, if I may.
Yes.
So
You
this
don't
case,
think she
this
should get a
case was,
lawyer?
I'm
You
sorry?
don't want her to you don't want her to confer with a lawyer?
Well, Your Honor, this case was filed on October 10th. It was originally set for hearing on November 14th. She had asked for an adjournment because she was going in for some sort of a medical procedure, and the court gave her a 5-week adjournment already. So she's already had one long adjournment. She's had plenty of time to find a lawyer. We have some very serious issues in our apartment community because of this tenant. And so we would like to have our day in
No, you
court as
have
soon as
very serious
possible.
issues because I have not done nothing but fight for my rights. And guess what? You can move me, but the fact of the matter, ADA and the dog department of justice is coming out here on y'all. I don't fight. What can I do but go in my apartment? What, I'm walking, running around scaring people? See, that's the type of people they are. He even lied when he filed the paperwork. Because if the property was already okay, I wouldn't have had to come and call and bug them. See, the issue is they don't want to spend money. See, I also lost 3 packages. The buzzer didn't work. All this stuff I had to call the city. They came out here and find them. So that's what the issue is.
So let me ask you this. And I know that we gave you the adjournment due to the medical procedure and you still got an issue. So I'm not sure if you had a chance to get an attorney during that period. But what is your defense to the fact that they just want the property back? Are you trying to say that you believe that the whole reason they want the property back is because it's some kind of retaliation? I mean, I'm not exactly sure what you're saying. Because you said that you're going to...
It's a retaliation, Your Honor.
Okay, and so you want to get a lawyer to pursue that as a defense so that you could stay there?
No, I want to move.
Ma'am, listen to me. Listen to me. This is a case where they want you to move. You have a right to defend it if you want to stay there and you think they're asking you to move based upon some unreasonable, illegal grounds. You have a right to defend it. And then if the court finds that they should not be evicting you, you'd be staying. But you're telling me you don't want to stay, that you do want to move. So my question is, and you don't have to do this today, but if you agree to enter into a consent judgment to give them possession of the property, then we could come up with a date that you thought you could move by. Or I guess you could still talk to a lawyer because due to the seriousness of your injury, I'd give you a brief adjournment to do that. But we would definitely have to move on this the very next court date, one way or the other. So what do you want to do? Do you want to agree that you're going to move and we try to pick a date that you can move by? And I'm going to tell you this, it can't be months away. Or the option is to give you a brief adjournment to come right back. I guess at this point, the only other date we'd have is Monday. We'd have to come back January 5th or somewhere in that week with a lawyer.
Okay, let me try to get a lawyer. I'm going to try to get a lawyer because okay, you talking about I got to move in 30 days.
Let me just tell you, if you get a lawyer, that means, and it's okay to do that you're going to defend against getting moved out. And you want to stay. And that's going to be your defense. That they don't have a right to move you out and you want to stay there. And I'm not so sure if that's really what you want to do. Because it sounds like
I do not, especially Especially when the maintenance man come in with his own key in the middle of the night. Yeah. No, I don't want to stay. Okay. What's the date? How much time I gotta mail?
That's only why I suggested that you might want to discuss agreeing to move and then just get a move out date. But I will give you the chance if you think you want to talk it all over with a lawyer, fine. But you're gonna have to be able to get one by the next date. Stick or not.
I'm not staying, Your Honor. The first one, the concession, whatever.
You want a consent judgment to move? How soon could you move?
I can't even drive for another 4 weeks.
Well, ma'am, you're gonna have to. That could be for months. I don't know what your illness is, but it could be months that you can't drive or feel like yourself.
I had a spinal surgery. I can drive in 2 to 4 weeks, man. I just need time to heal to even be able to go look at an apartment.
Okay. So what date are you proposing that you think you could be moved out by?
Middle of February. I don't even know. Middle of February.
Did you say middle of February?
Is that too long?
Well, that's what you said. I'm gonna have.
How much time? I mean, in the time, and the search, and this plus another thing is the holiday.
Man, we can't understand you. It's really kind of jumbled up right now.
I said the end of February. Is that too long?
Well, I'm going to ask Mr. Newman what his thoughts are on that.
Your Honor, my client certainly would be willing to give Ms. Anderson 30 days to move out.
So we're talking the end of January, ma'am. January 31st.
Can I ask you a question? Why did you ask me what I wanted, and then the lawyers? This is like you don't have a chance in landlord-tenant at all.
Okay, ma'am.
I can't do it in 30 days if they want to send the sheriff.
So here's the thing: with a landlord-tenant termination, they can't accept rent from you. I can't let you just live there with no rent.
I offered to pay up the rent. They agreed. They knew when I came in here that I was living off my insurance check. They have not sent it yet for me to pay all the back rent. They know I was in 2 car accidents when I came here. And not to mention the person whose name is signed on that lease wasn't the person who thing. But irregardless, I said I was moving. I just can't be out by January. I'll try my best. If they want to send the sheriff's, that's all I can do. I have no control over what nobody do. It wasn't even worth me. I mean, logging in because the decision was made already.
Ma'am, I don't know what you're talking about, a decision made. By who? Because I didn't know what this case was about until I just called this case a minute ago. So no decisions were made about anything. I'm just going to tell you, I'm not in a position.
Yes, it was because the girl, your clerk told me I would get an adjournment.
Okay. Ma'am, I don't know who told you what, but we gave you the one adjournment and I cannot give you it's not fair to both sides to try to make these kind of decisions without talking to anybody. And I'm not going to do it. I don't care how sick you are. I gave you the one adjournment. You needed to come here today to talk to me about how sick you really were. So I could make a determination.
I can't drive. I don't have transportation.
Okay, ma'am.
I can't drive.
Okay, you know what? I'm going to tell you this. I cannot let you just stay there till you think you want to move. I can't. But I can give you more than what he... Okay, you know what? I know you don't want to hear...
I said okay, ma'am. I did. All I said was okay. I agree.
Not all you said. You sat there and you told me that decisions were made. It doesn't make a difference whether you come here or not. None of that is accurate. I sat here patiently. I've listened to your concerns. He doesn't want you to move for 30 days. That would be mid-January. I'm giving you to the end of January. So I'm giving you more than what he asked for and a little less than what you asked for. That's fair. And you're still fussing about it, and there's nothing else I can do at this point. If you want to have a consent judgment and agree to move. The only other thing I can do is set the case for trial, and you can mount a defense as to whether or not you think they're doing a retaliation on eviction based upon whatever your circumstances are. You could get a lawyer, and if you win, you get to stay. That's what this case is about. But you don't want to stay. So it seems to me going to trial doesn't make sense. So we're trying to effectuate what you want and what they want. Both of you want to move. They want you to move. You want to move. The question is, how much time can you get extra? They cannot accept rent and still terminate this tenancy. So I am actually making them give you free space to live for 30 days, basically, until you can get out. And I think that's fair because you're getting more, that they're getting less than what they wanted. They only wanted 30. You're getting less than what you want, and they're getting more than what they asked for. So if you want to enter into a consent judgment, Mr. Newman can prepare that, meaning that you will give possession of the property back to the landlord, and you will move out by January 31st. If that's what you want to do. Is that still what you want to do? Okay. So, Mr. Newman, prepare the consent order that states that. Get it over to her where she can sign it. Or would you like to give him permission to sign your name? Either way, he can get it to you, or you can sign it. Or he can sign it for you.
I'll sign my name.
Okay, he will get it to you, and the move out date will be January 31st, and that will end the whole matter. You just need to get some help to try to see if you could get somebody to help you look around, make a few phone calls while you're trying to recuperate. So, Mr. Newman, you're going to prepare the order.
Yes, I'll prepare an order, be a consent judgment with a move-out date of January 31st, no money judgment, and I'll email it to Ms. Anderson so that she can approve it as to form and either sign it or authorize me to sign it, and then I'll upload it to the court.
Okay, that sounds good. Ma'am, did you have any other concern or question?
No.
All right, so that's going to conclude this matter. Good luck to you, and hope you have a good holiday.
Thank you very much, Your Honor.
Court does call the case of the people versus volatile.
Yes, Your Honor. Brandon Bird on behalf of Devontae Holmes. Mr. Holmes, can you please state your full name for the record? Devontae Holmes.
Thank you.
Your Honor, we're here today on the people's motion for in-camera review. I know the court's had a chance to review that, so we'll mostly rely on our written pleadings. There was just this letter that came from the defendant that had attorney Bird, BIRD on it, but also the address that we know to be the defendant's home. It was intercepted by the police, the sheriff's department. They have not opened it. They have not seen the contents of the letter. The people would ask the court to conduct an in-camera review of that letter, and if it contains privileged information meant for defense counsel, to hand it over to him, to never divulge the contents of it to the sheriff's department or the people. We don't want any piece of it. We just wanted to follow the process as that sort of got flagged by the sheriff's department as being slightly suspicious. Happy to answer any other questions the court has. I don't have the letter with me. Detective Pearson is not currently in the courtroom, but he can get a copy of it should the court rule in favor of the people to the court very quickly. It is in property.
The property officer's not. Property officer.
Respectfully, Your Honor, and I'll say this with all sincerity, I do trust your decision as a judge and your opinion and decision making. I am not arguing the fact that I don't believe that in-camera review should happen with this letter.
You're saying you're arguing that it should not?
No, I'm not arguing.
Okay.
I'm not arguing that. I believe that you should be able to see the letter and make that determination. But if you make a determination that it isn't privileged information, then it puts me at it puts me kind of behind the ball, because the fact about it is I can't argue. I don't have anything to argue if this is privileged information without me seeing the letter also. And if it is privileged information, we kind of get stuck in the bind, because the prosecutor can't argue if it is privileged information, because if I believed it was privileged information, I wouldn't want the prosecutor to see it, but they would have to make a counter argument.
No, I appreciate what you're saying, and I think I approached it from a different standpoint, because I approached it that and I was certainly going to grant the people's motion. I think that's an appropriate way to at least start this process. I think it becomes a bit more complicated, not just because of, now thinking about it, what you said, but also because there could be something in there that, while it may be a communication to counsel, is not privileged.
Sure. Correct.
Right? I mean, where on the face of it, one may think it's privileged, but it's not. The other thing that concerns me a bit is the letter was addressed to you, but at a different address.
And I believe that concerns everybody in this court, including me, Your Honor.
All right. And so, and I really, and I've been working it through kind of in my head that something, let's say it's a communication in a sense that could be to you, but, and on the face of it, had it been made directly to you, would be privileged. But now I'm in a circumstance where it's now made to a third party, which means that it is no longer privileged.
And what I would say, what I would respond with that, if I understand it is made to a third party, but it's not like he handed the letter to the third party where that third party will be able to see the contents. It's still a possibility that that envelope could stay closed and he could have said, turn this over to Attorney Byrd.
I agree. Yeah. I mean, and certainly that argument can be made. I'm just saying there's a sort of this whole, there's a lot of things that would go into it. But here's what I would do. I would grant the people's motion. The court will review it. All right. If, and taking into account what you're indicating, I think that the way we would have to do this is that if I were to determine that this does not look like it is privileged information, I think at that point I would have to give, without the people seeing it, I would have to give you an opportunity to respond to the court's determination. I mean, it gets a bit awkward, but I think and you could agree or disagree, but basically based upon what you then indicate to the court, and we'd have to figure out that mechanism, but what you would indicate to the court, then the court would then have to make a decision. And if I say, Mr. Byrd, no, that it's not privileged, then it goes to the people. If you convince me that it is privileged, then it stays where it is.
I agree, as long as the people agree, the people agree with that. Because on the flip side of the coin, I do see the people wouldn't be able to make a proper response if you say, Say you said, Mr. Bird, this is his privilege. I make my argument and you say, okay, Mr. Bird, I do see what you're saying. It is privilege. Now the people wouldn't be able to make it.
I understand that, and that may be just a flaw in how we're having to proceed. Because the cold-hearted reality is I could make a determination that it's not privileged and just turn it over to everybody, and then it's just out of the bag. But I'm trying, the interest that really has to be protected is your client's interest.
I believe.
And so I think, given that, that's who needs to see it and be able to challenge the court's ruling. The only ruling I think that you would challenge is where I say it is not privileged information. If I deem it all to be privileged, we're done.
I believe that's the best way to go also, Your Honor.
Of course, because I said it. Right?
Merry Christmas.
What Mr. Evans and I had talked about, if the court reviewed it and made a determination for it to be privileged information, we would never see it. And that's fine. That is the defendant's right. It is his absolute constitutional right to have those communications with his attorney. It just gets to it. I think we're going to have secondary pleadings, secondary hearings, something else, if the determination is that it's not a privileged communication, whatever it is. It could be something as simple as messing up the name on a letter, and it could be, Mom, I miss you, I want to see you again, something as simple as that, to something as nefarious as anybody could imagine. We have no idea without the court, at least at first, looking
at it and making
and
a
then
determination.
from there, figuring out what our next steps are. I'm not comfortable at this time saying what we would or would not, you know what I mean, without knowing, but I would like to start with the court just having that in-camera review.
Right. And what I'm just indicating is, and I don't want to lock down as to what further steps there would be. I'm just saying the first two that I see are the courts reviewing it. If the court says it's not privileged because it's the defendant's right, that they would get an opportunity to at least challenge in some mechanism what the court is indicating. And then we can go from there. Fair enough?
Fair enough.
Okay, so how do we get this to the court?
So I reached out to the property officer. The property officer didn't respond today, so I will follow up with her and with Detective Pearson. Hopefully, assuming that the court is saying, yes, I'm going to do an in-camera review.
Yes.
I can have them hopefully as early as tomorrow. Just bring it to your chambers.
Okay, and they should bring it to my chambers in another envelope, sealed, that says confidential, Judge Simpson. And the only two people that they should hand it to are either myself or Ms. White.
Okay.
Fair enough, Your Honor.
I will inform them of that.
I will also say that in case this ends up being evidence of some kind, we have to sort of figure out the chain of custody issues.
Correct.
So it may be that the detective waits outside or does something else in a separate room or in the hallway for the court to review it, if that works for the court.
Yes.
In the off chance that this ends up being something we need to use as evidence, we do have to think about that part of the procedure.
Gotcha. Okay.
Does that make sense for this?
Yes, it does. And
Your Honor, would that
yeah, you're right. Well, and so in that respect, I think it would be better if the detective arranges, if that's the process, that they call Ms. Weidling and arrange a time to bring it to the court
Happy to do that.
for my review. Okay.
And I just got one more thing to add, Your Honor.
Well, we give you too much time to think. That's our problem.
I don't even have to think. I'm ready. Stay ready, you don't gotta get ready, Your Honor. But respectfully, now, this is the thing about it. I know he doesn't have a complete right to privacy with those letters, right? But because basically the prosecution is just trying to find out if this is evidence that they could use against my client. But if this was I'm not saying, it might say something about the case, but it might not be relevant to, for it to be used in further proceedings. And that letter would never get to the prosecution anyway if it can't be used in further proceedings. So what I'm asking is, even if you decide that it's not confidential, do we have to turn that letter over to the prosecution if it's not relevant to further proceedings?
Well, I think there are really two questions that are being asked in that. Because the first part of that, or what may be your statement, is whether or not this would have, absent your name being on there, have been something that could have come into the possession of the people. I think that it could have. That I don't think is an issue. You then go to the issue of, let's say the court says none of this is privileged, but you're looking at it in terms of something that is, and I think you're intentionally using the word sort of confidential. Well, then certainly the issue of relevancy is an argument, a legitimate argument to be made as to whether or not it can be used and for what purpose. So I don't know that I can, without seeing any of that I could even answer that. So it could be a circumstance where it is not privileged, everybody sees it, but it's irrelevant for anything that we're going to have to deal with. That could be it. Or it could be parts of it are, parts of it aren't. There's no way for me to know it, certainly at this point.
All right.
Okay.
Understandable.
All right. So that does that. So they will get that to the court. Now, and I say this for benefit because I don't know what's in there. I'm not sure what to do should it mention Ms. Barnhart's client. That could.
Brooklyn versus United States.
I know what it says. So, but I don't know whose. That would be fine if it's his statement. But I don't know whose it is.
Okay.
You see what I'm getting at? I'm just speculating, but I don't know. But it may be that this all turns if something like that occurs. I'm just putting counsel on notice of that. And I'm not sure what I would do with it, but I would try to figure out something. Okay.
Boss, can you help me when you say Ms. Barnwell's client?
Let's say there's something in there, not from the defendant or necessarily even anybody that may be completely associated with the defendant, that says something about her client. Then we got a whole other thing that we got to try to analyze because it's not quite the breakup because it's not his. It may not be his statement implicating the co-defendant. If you're following. So it might be something else. Or I could just be bringing up things that we'll never have to deal with. But I don't know until I see it. But just so that we're clear that there may be a possibility of something along those lines. So, all right. And that's where it also gets into weird things because part of a statement or something might be privileged for one purpose, but not privileged for another purpose. And that we would all have to flesh out also.
Understandable.
Oh boy, I can't wait. Anyway, okay. So just so that we know, you've asked that Yes, Miss.
I think we're looking for an exam date, is my understanding.
And so we need Mr. Sweat.
I would like to get an exam date, but if we could get just I'd like to set this matter for exam to get this on the road, and I'm pretty sure Ms. Barnwell does too.
Today.
No, that's what I'm saying, today. But I'm asking, is there any way possible that we could potentially get a date to resolve that issue of the letter before the preliminary examination?
Yes, I can. But you're out the 30th.
I am. I have another exam on the 6th. I know this is going to be a pretty big. Exam.
This one.
This one, and I'd rather not have two exams on that same day. If I'm dealing with a case of this nature.
Are we talking about January, Judge?
That's what you guys wanted. So I would be looking at the 13th of January. I would set a final
Are you talking about for an exam, right?
for exam.
Yes.
That's what I'm talking about. But then they have to be brought out one at a time, Ms. Burnwell. So we'll have to repeat some of this when your client comes out.
Yes.
Okay. That's what I would be looking at. And then what I'd like to do is just set a decision on this motion, understanding what we're going to do, but I'd set that for January 8th at 3 p.m.
Now, as to that motion, can I zoom in?
You can zoom in, yes.
Me also, Your Honor. I got like 7 hearings, and one of them's over in 15.
All right, well,
22nd.
make a note that we'll put everybody in Zoom. We'll work with the jail, and the defendants can then be in Zoom in that one.
So I understand we're gonna be here on January the 8th, 3 p.m. for a decision on the the court's finding of the in-camera review, for lack of a better term. And then on January the 13th at 9 a.m., we'll have a preliminary examination for both defendants before Your Honor.
Yes.
All right, thank you.
Thank you, Your Honor.
Does that make sense, everybody?
Makes a lot of sense.
Okay.
That is our prelim day.
That is our prelim day. So I'm going to set the prelim at 11.
At 11, thank you, Your Honor. 11 a.m. on January the 13th.
Thank you. Yes. Court calls the case of the people versus Addison Sweat.
Good afternoon, Your Honor. Ashley for the people.
Good afternoon, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Adonis Sweat.
Your name, sir?
Adonis Sweat.
Thank you. And I'll trust that counsel will explain the motion, which really doesn't affect this defendant, at least at this point, to him, and I won't go through that. We are going to set preliminary examination in this case. So I set preliminary examination in person for January 13th, 2026, 11 a.m. That is before me.
Thank you, Your Honor.
On that day. Thank you.
Okay.
Bond, Wilkins.
Hi, how are you? How you doing?
All right, how you?
You might not be able to get it on Monday at the latest.
Very good. Great. He's got to roll. He's got to keep rolling.
All right, I just saw somebody today.
Court calls the case of the people versus Sebastian Phillips.
And Maggie on behalf of Mr. Phillips.
I have an order for forensic evaluation. Is that a correct statement?
Can I make a statement on that matter?
State your name first.
Sebastian Phillips.
Go ahead, sir.
So I believe my judicial pursuits in its origin, once informed, were squandered and stifled erroneously and imprudently against me and my best interests. I had people calling me, hanging up the phone. The public defender's office resorted to hearsay involving asserting inaccurate depictions of the actual police report without me having it in front of me. Let's see.
What do you mean by that?
Well, they didn't, when I was trying to get arraigned, she didn't make sure that I had the information in front of me to refer to make sure that the information was correct and accurate. I believe that is a form of abuse of discretion.
She wouldn't have had the police report. That's not the way the process works.
Well, she
At the
cited
time of your arraignment, it's very unlikely they would have had the police report.
Oh, okay. Well, I wasn't sure because she cited.
I know. That's why I'm correcting you.
Oh, okay.
Go ahead.
Well,
What's your next point?
Well, I'm just saying she cited information based on the police report. That's all I'm saying.
She cited information based upon what she may have known, but she may not have had that physical report.
I know, that's fine, but all I'm saying is it affected my ability to properly assess which direction I wanted to go personally for the matter.
What do you mean?
Because she said it was on Park Street. I looked up Park Street. It wasn't even.
So what does that mean? Why did
never
that
at Park
affect your
Street.
ability to do anything?
It's
Because after
misdirection.
the arraignment, this date would have been set.
I'm just saying it's a form of misdirection when you tell someone that a crime occurred at one point when it didn't actually occur. Once I found out that.
And so what prejudice has occurred to you?
I just believe it's abuse of discretion. And
Abuse of what discretion?
To steer outcomes in their best
To
interest.
steer whose outcomes?
The fate of my judicial charge in their best interest.
In whose best interest?
Theirs, not mine.
Theirs being whom?
Public defender's office.
The public defenders, guess what? You and them are on the same side.
I'm not
So
saying
if
that.
it's steering it in that direction, you
I'm
win.
just saying human error.
Okay, they're human beings. That happens.
Yeah, but
Okay, so what? Next
all I'm
point.
saying is, okay.
What is your next point?
Okay, so CMH workers were not informed. I had to inform the CMH workers. I'm a client of CMH.
Yes, sir.
And I do receive Section 8, and I do believe that, they're trying to oust and discriminate minorities who are affiliated with Section 8 and CMH.
Who's trying to do that?
My worker, Steve.
Oh, at CMH?
Yes.
I don't have anything to do with CMH.
I know, but I wanted to know if I would lose my Section 8 and my Social Security if I was ever charged with a crime. I haven't been charged with a crime.
I don't.
since I was 47.
I can't
I mean,
answer
18.
that. I think typically, depending on the nature of the crime, because I do a lot of the work, you're not going to lose Section 8.
Okay.
May have some issues with Section 8,
Yeah.
and I'm just telling you that based on my experience. Your individual case may be different where they may decide to take your Section 8.
Yeah.
So don't go saying Judge Simpson said
I
this
didn't
wasn't going to happen and violated some right. I'm just trying to instruct you that can happen, but it's rare.
Yeah. All I'm saying is that that information is pertinent to my choice of plea. So I'm saying if I knew I was gonna lose my Social Security or lose my Section 8, that would give me the decision to make, which would be in my best interest. And finally, I wanted to say that my doctor Bright, who's my doctor, she stated that she was ordered to kill me, and I filled out a form with the Licensing and Regulatory Affairs. I have a copy of the order. I gave it to prosecution, and I was abducted out of the ER at the hospital, and I reported to the University of Michigan Police, and the governor also was informed, so she's aware what's going on.
Governor Whitner?
Yes.
Oh.
I caddied for her stepdad. I was his personal caddy for her stepdad at Country Club of Lansing.
Yeah.
And also Justice Brennan Sr., just to let you know, before he passed away.
Cool.
Yeah, and I caddied in the LPGA for 3 years. So anyway, I just wanted to say that finally, CMH has resorted to consternation and contumacy involving the death threats, adulterating medications with opioids.
Ooh.
Pharmacy in conjunction with CMH.
Okay. Good.
And FDA MedWatch notification was notified. There's a procedure for that if it happens. So I believe they're trying to oust, avenge, and assassinate me. Based on the civic income, I can give you all the information. You can contact the governor's office too, because they know everything. And I know that I haven't been charged with a crime in years. And I just don't think that, it's something that is criminally intended or actually occurred to the charge that you suggested in the form of a felony. I think that's overcharged. It's just my opinion.
Okay. So here's what I'm going to do. I'm going to order a forensic evaluation as requested. I've signed the order. I'll set a competency hearing in this matter for
March 19th.
March 19th, 2026, 9 a.m. Bond, we'll continue.
So can I make the final request or statement? So you're saying that I can't request a motion to suppress and dismiss on this basis?
Do what?
Request a motion to suppress and dismiss the charges.
I don't know
on
what
these
that kind of
findings.
motion is. If you're looking to suppress evidence, then
No,
maybe you need
not
to talk to
necessarily
your attorney about that.
like immunity.
Immunity?
Yeah, from this charge, based on all that has occurred.
You want a motion for immunity?
Yeah.
Well, I don't know what that is, and I couldn't order that anyway.
I thought it was a legal term. I studied on.
Well, it's a legal term, but you're using it incorrectly.
Oh, okay.
And Your Honor, if I may, I did speak with Mr. Phillips last week, and
How'd that go?
I told him we went over options, and he was on board at the time with having an evaluation done.
Got it.
And I have been in contact with his CMH worker. They know that he had a hearing today as well. So.
All right.
That's only because
So
she
we
didn't
ought to be able to
agree
get-
with me.
Pardon?
She didn't agree with me.
Agree with you about what?
All the stuff I just told you.
I can see why.
Okay.
So here's what will happen is they're going to do the evaluation. We'll figure that out. We'll see you in March and see where this case
But
goes.
she won't even tell me the outcomes of that.
Of
If
what?
if I have an evaluation and what happens after that.
Well, it depends on what the evaluation says. There's no way for her to answer that.
Okay.
Yeah, I know.
Sorry, I'm not a fortune teller, Your Honor.
Pardon?
I'm not a fortune teller. I can't
It's
tell the
just
future.
it's civil procedures, legal procedure. That's all. She didn't cite the proper procedure once this forensic evaluation occurs and what will happen after that. What are my options? She didn't tell me any of that. And she didn't call me in about a whole week.
You got grievances against everybody.
No, it's not.
She's done a fine job. She got you here.
I know.
She's protected every constitutional right that you have. You ought to be thanking her rather than criticizing or saying she didn't do something.
I didn't mean
the
to
very
criticize.
fact you're standing here and like your liberty has not been taken and you've been allowed to say anything, you need to thank that young lady
I
standing next
appreciate
to
you.
you.
Thank you.
Thank you. Bond will continue.
Well, ladies and gentlemen, the piano's playing, the organ's whining. It's time for me to say goodnight. Those are the court cases I found for us today. And that's the compilation I was able to put together. There was a whole lot more that happened, but we can't squeeze all of it in 2 hours because, wow, today was a busy day in court. We'll see more of it later, I'm sure. Come on by Saturday. We'll be doing another live, 11 a.m. Central, noon Eastern. And just come on by tomorrow night. Probably have another one of these just like this. 8 p.m. Central Time, 9 p.m. Eastern. Don't forget to like and subscribe for more content. I drop videos between these live streams every single day, all day as I see them and as I discover stuff hot from the archive. Thank y'all for hanging out, chatting here in the court gallery. I'm your Lone Wolf Usul. I'm your humble host. I'm your curator for these here videos in the court gallery. And I appreciate every single one of you. And for night, I'm out. See you later, guys. Did I say the wrong time, Mama? I did say 8 p.m. Central, right? Yeah. And what Kira North said. Stay out of trouble. Else, you may find yourself being featured in one of these here videos. Good night, ladies and gentlemen. It's been fun. Y'all have a great one. Go see Pirates. I mean, Hawks. Marty, we all hope your team wins. Word.